Welcome to the Golden Keys. I'm your host, Trent Zimmer, alongside my beautiful wife, Karissa. We delve into the fascinating world of life in Minnesota, parenting, entrepreneurship, and real estate. We are passionate learners, and we love to share the lessons, knowledge, and experiences with you. Whether you're a parent looking for community, an entrepreneur seeking inspiration and guidance, or a real estate enthusiast looking to stay up to date with the latest trends and developments, the Golden Keys has something for you. Join us as we share insights, stories, and wisdom on this engaging and informative show. So sit back, enjoy the show, and let's go open some doors. All right. I'm very excited to bring a friend and absolute superstar. Actually, I have it written down. It's a Super Lawyers Rising Star for the third year in a row, which only 2% of attorneys in the state of Minnesota are recognized as. So she's pretty awesome. Her name is Sophia Grotkin, and I'm going to let her just get right to the point here. Sophia, tell us a little about you and maybe some cool things about why you're here today.
Thanks, Trent. I don't know if people can see us right now, but now you just made me red in the face. But thank you for those accolades. Yes, I'm Sophia Grotkin of Ranich Care and Grotkin. If that's a little bit of a mouthful, we refer to ourselves as RCG Law. We are a boutique law firm located in Edina and servicing family and estate law all throughout the metro Twin Cities area. And we kind of refer to ourselves as your family's law firm because our spectrum of work addresses everything from like beginning of life relationships, cohabitation agreements, antenuptial agreements, all the way to end of life planning. So we have the great fortune of being able to be a part of our clients' lives, sometimes in the happy moments and in the more difficult ones.
I feel like I need to know what a cohabitation agreement is.
Well, relationships have changed a lot over the generations, and not everybody gets married, but a lot of people have life partners now. And so instead of a lot of people have heard the word prenup, or we call them antenuptial agreements in Minnesota. People who are not married have the option of having a cohabitation agreement, which means we live together, we're not married, but we have rules about what's going to happen during our relationship, and if the relationship were to end in a breakup or death.
College roommates aren't getting cohabitation agreements.
Yeah. Or maybe they are after they read this podcast.
Okay, I'm taking, as a dad of a daughter, I'm taking notes. Cohabitation agreements.
There you go. That's going to be the first conversation. Poor Zoe.
Oh gosh.
So, we just went through a process with you, Sophia, and I'm okay with sharing that. We just went through a process doing some of our own estate planning, and there's so much to it. And the reason why I think this is going to be a really great conversation is because I don't remember hearing anything about this growing up in school, or even from parents or mentors or anything. And so it's like, why are we just learning this now? And how can we share what we just went through with other people our age? Because I know for a fact, most of our peers either haven't done this or probably aren't planning to do it until it's probably too late, right? I would guess that happens often, where people are like, I'm invincible, it's never going to happen to me. And then it happens to them. So,
well, we witness that in the real estate world, right? We run into clients that do not have a plan, and then therefore it holds up transactions on the real estate side. And I can't imagine what else, it's not fun for anyone.
So maybe we just start really, really simple. And why don't you just explain to us what is estate planning? What does that even mean? I'm going to question stack. I'm notorious for that. What is estate planning, and why should everybody be thinking about it, and at what age?
Okay, I heard 3 questions. If I missed one, Karissa, you hold me to it.
Yeah.
So what is an estate plan? An estate plan is a collection of legal documents that do 2 things. They transfer your assets, your estate assets, at the time of your death, and we all at some point will die. And then it also includes a collection of living documents, which direct how we want to be treated from a medical standpoint and from a financial standpoint if we're not able to make decisions on our own, if we're incapacitated either temporarily or permanently. So it's a pretty important collection of documents. And I echo exactly your feelings, Trent, where it's like, I didn't think about that until, honestly, even being an estate planner myself and working in the family world until I had kids, right? Until I had kids and until I started to develop some wealth of my own. So that brings me kind of to that next question of when do we do this? When do we prepare this collection of legal documents for clients? And my answer is, in general, it's a very attorney answer. In general, typically, it's when you when you have assets to give to another person. So once you have a 401k or an investment account, or you buy your first piece of real property, or that's when you can create your first estate plan. When you should prepare your first estate plan is once you, if you've established a business, or if you've had children, or you have anybody in your life that you are responsible for financially. Those are real triggering events where it's like, it's time to talk about these things and create a plan. Because planning is everything. And like Karissa mentioned earlier, we want, we believe that it's really important for families to be able to grieve if their loved ones have passed away, and to be able to focus on, what the reformatting of their family looks like after the death of somebody so important. And we want to minimize the collateral losses. And one of them is these mishaps with property, and these mishaps with money and accounts that we wanted to go to kids or our spouses, but are not, because we just didn't think that either we didn't address the issue of that is inevitable, right? Or we just didn't get there because we were living our lives and hopefully having a great time doing it. But that's what my job is to just kind of hone us in temporarily to make sure that we've got all of those questions answered. Who's my estate going to go to? What's going to happen to my children? How do I want to be treated if I'm unable to communicate that on my own? So that then once we've prepared these documents and established those ground rules, you can go live your life, and then have somebody like me kind of pulling you in every couple of years saying, so excited about the new baby. Let's put, let's include this person and think about this person in our estate plan. Or great job. Third business. Awesome. Let's make sure that we've planned for, the succession of that business if something were to happen to you. Right.
And I know we asked this question while we were going through the process, is amendments. We're familiar with amendments in the real estate world. And I was like, how easy is it to amend something that we put into our will, right? So if the person we appoint to take care of our children, if they are no longer living in the future or unable to take care of them because something happens, gosh forbid, what does that look like? That was one of my lingering questions, because I'm a what if person, and I like to have levels of security and have a safety net around that. And it seems to be no problem in addition to your check-ins with us, but just a simple amendment on a line item or a paragraph or some part of your will is fairly easy, correct?
Yeah, it is easy in the grand scheme of things. It's the most important thing is to have that initial plan in place. And then it's a lot easier to come in and say, hey, we had a new baby. We want to add them to the estate plan and create a one-page amendment or codicil, than you don't have to come in and completely redo your entire plan to do that. It's, and to that point, Karissa, I have some people who say, well, shouldn't I be done having kids, or shouldn't I be done accumulating property, or be in my last, the home I want to, retire in before I create my estate plan, because then I know what's in front of me. And I always say, no, we do that. We do this along with you because
Right.
you don't know when you're going to need these plans to be in place. And so now is the time. Now is always the time. It's not after the fact.
Absolutely.
How,
Absolutely.
how long, I know this is a really generalized question, but how long is a will? Like, are they,
Like page. I mean,
yeah, like, are we
I'm not
talking like,
gonna.
is this
I
like
will
a giant
say
stack of, is this like a
I will
giant
say
stack of paper, or is this like
I
3
had
pages?
well, I had a client recently who was, oh my goodness, bless her. She was donating her estate to 63 different charities.
Oh
And
my
so
goodness.
her will was like 25 pages long, but a basic will is usually, I mean, they're about 8 pages.
Mhm.
Trusts are different, those have a little bit more meat to them, but we're doing a lot more in those documents because they're addressing, all our assets, not just probate assets. So, I mean, and I do, I'll toot my own horn a little bit here that I do, when I look through estate planning documents, a will or a trust, there's a lot of legalese or legal jargon. People like to use that term. And I walk through every single page and I put it into, regular layman person terms, and it makes a lot of sense to people. So
Thank you.
it's not, I haven't had one client yet who's walked out saying, oh, I still don't get this. They're kind of like, oh, why don't they just say that in these documents? Why don't they just say what they mean to say? And I'm like, well, when I'm queen of the world, I'm going to change that.
Listen, call it what it is. You're dumbing it down.
There you go. Estate planning. Yeah.
That's
Estate
called dumbing
documents
it down, and I'm
for
okay with
dummies.
admitting that. Yeah.
There you go.
That's so funny. Okay, that's a great opportunity actually, because you said a couple words that I think people need to understand, myself included. Talk to me about the differences between wills, trusts, and then like I know you said the probate process has to do with your will, correct? Trust avoids probate.
Correct. Wow. You have
You've been
graduated.
listening, Trent.
I mean,
You have graduated.
I know enough to get by. I still need it dumbed down though.
Enough to be dangerous. Stick with me, Trent.
Yeah.
So the difference between a will versus a trust is this. A will transfers your probate assets, and probate assets in general are just assets that do not have the ability to have a beneficiary designation associated with them. So think of like real property naturally does not have a beneficiary change form like our 401ks do, to say if I pass away, this real property goes to my nephew in Colorado, right?
Sure.
So that's considered a probate asset. Vehicles are generally considered probate assets. Everything that doesn't have this beneficiary designation transfer. So it's limited. Wills are actually very limited. And then it also gives you the ability to appoint a guardian for minor children. A trust, on the other hand, is an all-encompassing estate planning document where you can transfer all the assets you own according to the document, what you indicate in the trust document, probate and non-probate assets, as well as you can create some special terms for your adorable beneficiaries who are typically our children, as to, if when they're ripe to receive our estate assets, when will that be? How old will they be? Will they work with a specific financial planner? Are there any rules associated with that? Does a child have special needs where we need to make sure that those needs are met throughout their lifetime? Those types of things. The reason why people really like trusts is because people actually find them to be a lot simpler than working with the will, because you just all of your assets can be transferred into the trust at your death or during your lifetime if that makes sense. And then at the time of your passing, there's one bucket basically to divide out to your beneficiaries. And that bucket is available immediately, practically, to your beneficiaries rather than having to go through probate to receive those funds. And that brings me to the other compound question that Trent had, which is,
I told you,
which
question
is,
stacking master.
which is what is probate? And probate is essentially our Minnesota's legal process, managed by the Minnesota court system to monitor the transfer of a decedent or a deceased person's estate. So instead of an individual that you might appoint in your life to just go ahead and, okay, if you pass away, let's see, like the Zimmers have this interest in Keller Williams, and you say this is where it's going to go. Instead, a court will be looking at that, and it will be a public document, and it will provide an opportunity for creditors and other curious people to be privy to your entire estate and who your estate will be going to, and then we'll transfer those assets so to the rightful persons, whether it's dictated by statute because you didn't have a will or via the will. So that process takes a really long time, and unfortunately, in Minnesota, we are still getting pandemic event notifications on probate cases. So we're very, very behind on being able to address a lot of probate matters. And so it can take years rather than weeks, months to administer somebody's estate, where, you know, the trust estates that I'm assisting clients with right now is weeks to get things transferred over, or months. But that's much preferred over years.
Yeah,
Interesting.
for sure. So would there ever be a reason somebody would have more than one trust?
Yes, that's a really good question. So, you know, we look at, and I like to be, sometimes I think less is more when it comes to when it comes to legal documents. The biggest overarching theme is what will you accomplish, or what are you more likely to be able to manage during your lifetime so it can be effective. But there are certain instances where it makes a lot of sense for someone to have more than one trust. One primary reason is if you're a high income earner, you have a lot of asset that will potentially transfer at death, where you would be far over the federal or Minnesota tax incomes at the time of death, where you might want to divvy up that responsibility between spouses. That's one reason why you would potentially have two trusts rather than one joint trust. The other reason would be if you have a child who has special needs, or that requires a supplemental needs trust or a special needs trust, so that child can be eligible for medical benefits that is essential to their care, and not unintentionally, by your gift of an inheritance, bumping them out of being able to receive those funds, or care that they otherwise really, really need. The other reason is because you might want to, in your children's adult lives, establish trusts for them while you're living, and be able to fund those trusts for them, so that at the time of your passing, there's nothing more that needs to be done to transfer assets to children, even young adult children in their 20s, 30s. And there's a million other reasons. Life insurance trusts, your financial planner might recommend, based on your worth, that you should have a life insurance plan, especially if you have kids or a business. And a lot of times it's very helpful to have that in a revocable life insurance trust, so that can protect you from various tax consequences or credit issues. But in addition, it's irrevocable, so it provides a lot of assurance to your estate that those funds will be available when they're needed. There's a list of things, Trent.
There are different types of trusts too, right? Like you just said, irrevocable. There's revocable trusts, right?
There's revocable, irrevocable. The main point to, I think, and I could talk your ear off on the number of different trusts and the meaning, what the benefits are and drawbacks and options are. But I think the main theme is just, if you think that based on, my recitation of a family structure, if you have a business, if you have multiple children, if you think that you might be in a high income bracket, if there's any special circumstances in your family, it's probably a good idea to just try to meet with an estate attorney and have them walk you through the different options, because it's really easy to get kind of stuck in the weeds or get confused about, okay, what do I need versus like, what are the options? I think that sometimes there's so many options out there, but it's like, what do I need? What does my family need to optimize my family's goals? I think that's the biggest thing. And I always try to really focus in on that when I meet with my clients, at least.
Yeah.
Interesting. So when someone gets a trust established, I've seen people in our industry put their primary residence in their trust. So instead of in their names, they'll put it in their trust. Why would someone take title with their trust versus their legal names?
Individually?
Yeah.
Yes, that there's two ways. There's two ways that you can title property when you have a trust. One is to just transfer that asset into the trust right away. And the other is to prepare a transfer on death deed to have the trust be in the trust's name and owned by the trust at the moment of your passing.
Sure.
The reasons why people will do that is it avoids probate, because the primary asset that most people in Minnesota will have that's a probate asset at death is real property. And so it has to go somewhere. It has to have a transfer on death designation, whether it's an actual transfer on death deed, or it has to be held in trust. And a lot of people will just feel, let's just have it in our trust during our lifetime, so we know that it's done.
Right.
And title has been transferred. The other reason for that is ownership. It's kind of a great estate planners can think differently on whether or not it shelters you from creditors or legal ramification by having an asset in trust, but it certainly does assist in designating intent or trying to create specific ownership of that asset.
Sure.
But I think the primary reason is to avoid probate right away. And also, again, if you're a high asset family, it designates, if you pass away and the house is in one spouse's estate over the other, then that assists in the division of those estate funds to assist in trying to bring down that tax burden. So there's a lot of great benefit. One drawback to transferring your real property in trust during your lifetime, however, is if you're in the busy stage of your life where you are moving. So like it seems, and you guys can speak to this more, or maybe you can speak to my family, like at least my family, where it's like, it seems like every child you're like, okay, we have to move again. We can't just buy the house that we're going to be in for the longevity of our family life. It can be, there's a consequence for transferring your real property into a trust. And that is that you need to make sure that you apply for homestead status. And I know that you guys actually assist with that, or your partners do, but a lot of people don't know that. And then there's a very unhappy tax consequences at the end of the year if you haven't done that. So if you're somebody who that's too much, you can just, that's a question that I ask my clients to make sure that we've made the right designations for your property.
That's super helpful.
So so having it be non-homestead would give you a penalty if you had it in a trust? because a lot of investors put them in trust too, because
Mhm.
it's one more layer of protection and liability.
That should be okay. Carissa's example was more like the
Your
house, like
primary
the family
residence.
home.
Yeah.
But, and so that's where there would be that consequence. But the non-homestead, I haven't seen, I haven't come across an issue with that
Mhm.
yet.
The reason I asked the question is my parents had recently purchased their the home that they foresee themselves in until they are either no longer here or have to unfortunately go to some type of a care facility, and they
Mhm.
put it in a trust. And I was in communication with their attorney, got all of their documents. And my other question for you was something like this. So say decades from now, the inevitable happens, right? I lose my parents. I inherit their trust. Do I appoint you as my representative to help guide me through the process in receiving the trust, or is that not necessary because they have their own attorney that holds their trust? How does that work? Because in real estate, we are,
Mhm.
a seller will work with their real estate professional and a buyer will work with their real estate professional. And you feel protected, right? Because you chose that real estate professional to, guide you and help you and represent you. Is it the same in your world or no?
It's a little bit different, but there are definitely similarities.
Okay.
The personal representative is typically, they take on the personal representative or trustee, they take on a fiduciary role, which means that they have legal obligations to carry out the administration of the trust. So you would have a legal obligation to administer your parents' trust
Sure.
properly.
Okay.
And so it's always advisable to hire your own attorney to prepare to guide you through that process. It's the person,
Yep.
it's the deceased person. It's your parents' wish that you, Karissa, be the person
Yep.
that's managing the administration, but you probably need a coach, right?
Yep.
Which is essentially the personal representative or trustee's attorney's role is to make sure that you're following all of the rules and doing everything correctly. However, I will say that it's really fun and very seamless when an estate, somebody whose estate plan I prepared, I can also administer.
Sure.
And so it can sometimes be the same attorney as long as everyone's on the same page as to what the intent of the document is.
Sure.
When there's disagreement on that, that's where we have to separate each other and have separate lawyers. But that's probably a discussion for a whole nother day.
Yeah. Well, and then I can imagine too, like the attorney that drafted these, they may reach an age or a mental
Yeah.
state where they're not able to perform their duties, right?
Mhm.
So that
Yep.
might get transferred. I mean, there's so many different things that can happen.
Oh my
But
gosh.
That's such a Karissa thought.
well,
Well,
I
you're
feel
right
very,
though.
yeah.
You're right though.
100%
The estate planning industry is actually, it is turning. I mean, it is turning, and I'm not gonna lie and say that I haven't had an instance where someone's had to come to me, a couple of instances where someone's come to me because their estate planning attorney passed away or retired.
It's
You know,
sad. It is
it's
sad.
just, I mean, it's just the nature of it. Yeah.
When
I
my
wouldn't
dad gave me the documents, I like put it in my safe. I also have it in, some other secured places, but I was like, okay, how old is your attorney? And this is like years away. Like, where does he live? My dad's like, are you serious?
That's
I'm like,
so
well,
something
This is
you would
cholesterol
do.
levels. Did he run every
Okay.
day?
and he was like, well, it affirms my decision in appointing you the person to administer this. And I'm like, here's my attorney's contact information if you need anything. And he's like, oh my goodness, Karissa.
Absolutely.
Like,
Whenever people have multiple kids and they're like, well, we don't know who to appoint as the personal representative or trustee. I'm like, well, which one loves spreadsheets the most?
yeah.
That was actually
the firstborn.
That was going to be one of my questions is you probably can't, but people have to ask you the question of like, who do I put in charge of this? And of course you say the whole spreadsheets thing, but like people who actually have trouble selecting, or maybe there's somebody in their family that's like awkward, that's not a beneficiary, but maybe should be.
Yeah,
And then they find out they passed away. Do they ever come knock on your door and they're like, hey, where's my check?
absolutely, that has happened.
So
and it's
awkward.
crazy.
It can be awkward. You know what I try to do to prevent that is I try to have, I know that if I've met with the the couple or the parents, and we have a discussion about what the family dynamics are. And if we sometimes will have a family meeting to kind of give everybody a lay of the land as to what the expectations are. But I have unfortunately had a case that came across my desk within the last year where none of that discussion was had, and one of the children was removed from the estate plan. And it was a really emotional and difficult time for this client, because there was just no understanding as to why or how that could have happened. Was it a mistake? Was there a reason? And that's where all the speculation happens. And that's why as a parent, and as an estate planning attorney who wants to make sure that we're trying to prevent problems from happening in the first place. Granted, we can address the problems once they're there, but it's better to just kind of prevent things so that everything can go smoothly, so that everybody can just grieve properly rather than have these things come up. So.
Well, and I think, like you said, just asking the right amount of questions up front. That I personally went through a situation where the blood relative passed away. She had a spouse though, and that wasn't considered in the estate planning from the parents' side of things. And you don't, like, if something happens to me, but Trent and I still have kids together, and I was to inherit, my parents' trust, is he still being considered? Or the bigger question, are my kids still being considered? Because I'm out of the mix. So there's different things that, and to them, they just didn't think that, because you think of, okay, well, I'm going to pass before they're going to pass. Right.
Right. And in your head, you already have that kind of hierarchy of, who should be receiving benefit and those types of things. And unfortunately, the law doesn't always coincide with your moral radar, right? Totally. And so or your family dynamic. And so that's why it's so, we could talk all day about some of those horror stories. But at the end of the day, it's just the reason why people would prepare estate plans and do this periodically throughout their lives is because we want to have a say in what happens. And that's the kind of the overwhelming theme over the last couple of years, right? Is that people want to be able to have some autonomy over this hard-earned wealth, or over our, the children that we just love so dearly. We want to make sure that we're a part of that decision-making, and that it's just not something that's up in the air at the end of the day.
Yep. You want to make sure your legacy lives on. And that's why we do what we do every single day, is for ourselves, for our kids, for our kids' kids, for their kids. I would love to be there for, that, but we want to make sure that that legacy is carried on. And if we didn't talk to you, after this year, that trust would just never be amended. And then those things wouldn't be able to carry on as easily. So it's very
exactly. Important. You said it perfectly, Karissa.
So you mentioned in some conversation between you and I that there was some hot topics in your world right now, and I can't remember what they were, but I know you probably remember.
Yes.
I have them in my notes somewhere on my computer, but
there were just two things I wanted to make sure to address.
Yes.
One big issue that's been coming up a lot, and with actually very tragic results, is a misconception in Minnesota law. If you don't have land conveyance documents prepared for your real property and you're married, I want to know, what do you guys think? Who do you think gets your real property if you're married and you have kids when you pass away?
Just knowing where we live, probably the government.
Okay, so most people. Okay, good guess, Trent. But you would think that it would go to your spouse, right?
Absolutely, yes.
No, it goes to your kids, even if they're minors. So you need to have an estate plan in place if you are going to have any, if you're going to have any real property owned by you that's not in joint tenancy with your spouse. This has happened a couple of times, and it just it's so heartbreaking because like this surviving spouse does not need another problem, right? They've got a lot to deal with, and they've got minor kids or kids in general that are dealing with a grieving a parent. But that's one big hot topic. Legislature needs to address that or clarify that.
So if it's joint tenancy, it's going to go to the spouse.
Yes.
But if it's tenants in common, wouldn't 50% go to the spouse? And if that's how you, right? Tenants in common is half and half.
Right. That's correct, Trent. Except for if your kids are minors, they can't inherit real property. So there has to be a conservatorship. There has to be court involvement to place that land in ownership and management while they're minors. And in addition, if we're talking about a primary residence or multiple residences, at least in, former client's case, like that house needed to be sold to be able to pay for kids and their needs over the next couple of years. And so unfortunately, it just kind of, unless that's your intent, right, then got to do some estate planning to make sure that everything is in place the way that it's intended. So that was the one thing I wanted to it was on the top of mind because this issue came across my desk when about the time a couple of weeks ago that you had said, hey, would you come on this podcast? And I thought, I'm going to make this PSA.
I love it.
I like it.
Thank you.
And then the other announcement I wanted to make is that, so with the family law piece of my business, we are actually finding that a lot of clients are becoming very sophisticated, which is good. And needing some more specialized services or more a la carte type services, if you will. And so our firm is actually going to start transitioning to including some of those more limited scope services to make legal work much more affordable, accessible, actually in some ways more sophisticated for our family law clients who need help with like child support matters, antenuptial agreements, custody divorce cases that are pretty amicable, those types of things. And so we're really excited to be rolling that out this summer.
Yeah, that sounds amazing.
Awesome.
And actually that leads me to a good question too. And I think a lot of cloudiness around this probably is because people assume it's crazy expensive or they can't afford it. Because anytime you talk about lawyers or attorneys, right, people think dollar signs. And so that's really cool what you guys are doing. And also if you can share with me a ballpark number of somebody who maybe doesn't have a super complicated life and tons of assets. If somebody wants to come in, they've got a couple kids, a house, what does it cost to do some of this stuff for them?
That's everyone's question. And it would be mine if I walked into an estate planning or family attorney's office too. The easy answer, I'll start with that one first, with estate planning is we actually provide all of our estate planning services via a flat fee, which is not necessarily how every firm does it, but we think that provides a lot of peace of mind for our clients to be able to know this is what I'm getting. For a flat fee. And then it's our estate administration is based on an hourly rate, which is the kind of our traditional way of billing in the legal world, but we provide ballparks. So we'll go through and go through your work. And if it's like, I just need help funding, transferring, then maybe that's only $1,000, right? And I can give you kind of a ballpark of and a cap. That's really helpful for people. In family law, the whole reason why we're doing doing a la carte is because it's so, usually it can be a litigated process. And so we are really limited by how both parties are going to respond. And so it can get really expensive really fast. And by really expensive, I mean like $50,000, $100,000 in a fully litigated matter with kids, right?
Right.
However, what we are doing is we're offering ourselves up to be consultants where you are, negotiating with your spouse, but you have us in the background providing you with the legal advice so that you can be smart going into things and you're not, forgetting things or putting yourself in a difficult position. So it should, without, I'm answering your question by not answering your question, Trent, basically.
Classic,
And
classic
saying,
attorney.
and saying we charge an hourly rate, but we are able to kind of limit our scope to basically, you know, whatever you can do or need to do. Because I've had clients who are like, they've gone to mediation together and they just need me to look at the document, and it's like, okay, here's your, you know, I'll give you a flat fee of $500 or something to review you and spend a couple of hours with you and make sure that everything looks good. The reason why you need to do that is because our, you know, firm we actually just had a case that we were involved in that went all the way up to the Minnesota Supreme Court because non-represented parties were forgot or didn't put an asset in their divorce paperwork. And then years later, when we were trying to divide it, there was a disagreement as to whether or not that asset was to be divided. The Supreme Court has since said and spoken 3 years later that you must disclose all assets, all assets to be divided. And so that's going to finally be resolved, hopefully soon. But it's just all the more reason where it's like, we need to become more accessible as attorneys. We have to be approachable. We have to make this work so that, because everybody, you know, everybody deserves representation and should be able to have it at an accessible price.
Absolutely. And protection. And just, I know for me, when we were going through the process, one, I was pleasantly surprised to the packages on when you broke it down for us personally in looking at our portfolio of things. I was like, wow, this is really nice, because I was also doing it for peace of mind as a mother. And since having my third child, especially, I have anxiety over the simplest things, you know, like we go on a trip together. I'm like, oh my goodness, we're flying on the same airplane. We're doing all these things together. Like you just start to, and he doesn't think about anything. And I'm like, I am carrying all this stress and I feel like my heart rate is elevated. I can't fly anymore. I like fly with lavender essential oils, like literally bathed all over me.
How many miles are on this plane?
I'm only laughing because I just can picture this. I can just picture Trent like, you know,
like minding his own business, which not to stereotype or classify and put them into a group, but I feel like a lot of men are like him in that their minds don't race. And it must be like my motherly instinct or something, but my mind is just always racing. And since going through this process, it has just brought in so much peace for me, and every mother deserves that, right? You start to think about all these things that you're responsible for you know, bringing them up in this world. And then, you know, I want to also be able to have peace of mind when they're married and with their kids, knowing that my hard work and my legacy will live on through my grandchildren, through hopefully my great grandchildren, when I get to meet them and hold them and see them. And so, yeah, that was the biggest part for me, was just that peace of mind. And I love that you guys are doing that a la carte. That is so amazing. I'm so proud of you. Look at you.
Do you have one of those timers on your desk? So when I call you, you click it.
Oh my
gosh. And then like 30 days later, I get an invoice for like the 30-second phone call we had together.
Okay, that's one of the reasons why I started my own boutique firm, Trent, is I didn't want to have to start my time clock every time I talk to a client.
I was just gonna say, Karissa, we're gonna get an invoice for this. I'm just kidding.
You definitely owe me pizza.
That's why we love you. Okay, I do have one more question. It's quick. If I'm like laying on my deathbed and I don't have a will, can I just like write one on a napkin?
Okay, Trent is talking about a holographic will, which is a handwritten will that's not witnessed or notarized. And unfortunately, no. But there are options if you are on your deathbed, Trent, and if you have gone on vacation and you like got stung by a jellyfish or something and it went sideways, and you can, I don't know why. That
would be a gnarly jellyfish.
Karissa's fears.
Yeah.
And And there are, I mean, so in Minnesota, in order for there to be a valid will, it has to be written, which there's case law to say that it needs to be, that means typed. Some people disagree with that. And then it has to be witnessed, and you have to be of sound mind. So I don't know if you are of a sound mind when you're on your deathbed and stung by a jellyfish. Great minds differ on that. But you potentially could. I wouldn't risk it.
Yeah. So you wouldn't even need a notary. It would literally just have to be witnessed
by two witnesses, and you have to be of sound mind, and it has to be typed. So I don't know if you're able to. Yeah, I mean, there's a lot of things that would need to come into place pretty quickly.
Perfectly.
If you're on
I was just curious because like you've seen it, I feel like in the movies they like
I've had
that, right?
yeah, I mean, I've had those wills where it's written, and it's a tough situation.
Just written inside of,
let's just say that if you do it that way, there's a likelihood that it's going to be litigated anyways, right?
Yeah,
true.
Gosh, we've talked a lot about a lot of heavy stuff, right? In your world. What are some aspects, or what are some things that you do within family law that bring you joy, that are mostly happy moments for people?
Well, I know it is heavy. I recognize that, and that's not lost on me. But what I love about my job the most is being able to be that, true north for my clients, and being able to have them meet and talk with me in my office, and maybe they're anxious and they don't know what's going to happen. There are tears, and when they talk with me, they say, "Oh, I just feel, I know that life is uncertain, but I at least know that I have a plan now."
Mm-hmm.
And that can just really ease a lot of worry and stress. So that's one of the things I just love about what I do, even though it is difficult work. And, I also love when I see my clients come for full circle. So in death and divorce, those are two very traumatic life instances. And I love seeing when things kind of work out for my clients at the end of the day. And recently, I actually had a client who was a divorce client of mine. Unfortunately, his relationship ended, and there was a divorce that happened, and approached me over the summer and had found new love and was getting married. And so I got to assist with the antenuptial agreement, or prenup, in this new marriage. And I got a Christmas card in December from this new blended family. And that actually included the former spouse, which is super great to see that there's co-parenting happening. And then I also got a card of them out spring breaking over this last March. So it's really great for me to be able to see that clients, when I say things will get better, they sometimes really do. And it's exciting to be notified of that, because sometimes I don't really get to see what the results are.
Oh, absolutely.
You're kind of like us. You're like a counselor on the side.
Yeah.
Yeah.
Well, I'm sure it's fun for you too, is to see the legacy in works too. I mean, the circle of life, right? We're all going to die at some point, and hopefully we all die in our 90s, and it's just becomes that time. But when that happens to people in their 90s, is seeing their children come to you, everything's dispersed and, handled, and then them living out your client's legacy. Like, I feel like that would be really fun to see.
Oh,
and
it
so
is
fulfilling.
It really is, especially when, at some point, I hope that we all can become at peace with the fact that we will move on from this world, right? And it's really cool when I see clients who have kind of come to that place, and now we're making a plan for what's going to happen with all of their hard-earned wealth. And I actually had a client who worked in a it wasn't a high earning job at all, like minimum wage job, but was very intentional with his income and assets throughout his life. And instead of providing his funds to, what the Minnesota intestacy statute would provide for him, he actually gave all of his earnings, which was in the 8 figures, to a local charity, and I got to be a part of that. And it was just
Oh,
so cool. It was so cool because when my client passed, it was like, this charity is just, they are going to be blown out of the water, and they have just no idea that this person who's been involved with their work throughout his whole life was planning to do this.
that's so cool.
Great. There are
That's
so many,
so
there's great opportunity.
Oh, totally.
That's awesome.
That's so fun. Cool.
Well, the last thing I think that I have to say is my takeaway, which was at the very beginning. And you mentioned that families with plans have time to grieve. And you and I have worked together a lot on families that necessarily have not had time to grieve because the process wasn't set up. And this stuff can like rip families apart when somebody passes away and there's no plan.
Yeah.
And so I've never heard it said like that before. When you said making a plan can allow you time to grieve when that important person leaves is like, wow, that's
powerful.
That's
It
true,
really
because
is.
instead of spending all of your time worrying about all this stuff and all these things and where it's going to go, you can just focus on what is happening. And so I wrote that down right away. Right when you said that, I was like, whoa, that's crazy. That's so true.
I'm so glad that you're taking that in, because that's really, that it really is our goal, where, you know, we deserve that. Our families need that. And so let's make that possible for them.
Yeah,
absolutely.
Sure. All right.
Awesome.
So if somebody wants to reach out to you, what's the best way to do so?
Yes. Please email me or call me, Sophia, Sophia, at rcglawoffice.com. Or you can always call our office at 952-855-8872. And what's great about the boutique firm here is that you will be able to speak with me, Sophia Grotkin, or the Randon or Shakira in our name. So we just love working with our clients directly. So
that's awesome.
Please give us a call if there's ever a need or questions.
We'll put it in the show notes. And if you missed all of this, you can text Trent or I, and we will connect you with Sophia. She's the best.
Thank you so much for your time. Appreciate it.
Yes, we love you.
Great. Thanks, Sold.
Bye.
Bye.
Bye.